Judge Shapiro, we're a few minutes early, but I wanted to let you know that it looks like we have attorneys for each of the parties as well as the court reporter ready whenever you are.
All right, give me a couple of minutes.
Sounds.
Okay. Okay, let's get this show on the road. Everybody's here and everything. So here, okay.
Would you like me to bring them in?
Yes, please. Thank you. We have a full house. Is the court reporter here?
Yes, they are.
Okay. All right. Very good. Thank you. All right. So it looks like everyone is here. I'm going to call the case in just a moment. There's lots of issues for you to discuss in the request for the preliminary injunction. But would you both, whoever argues, also address that if I don't grant the preliminary injunction, will you excuse me, please? I'm very, very sorry, but I just realized my iPad's out of juice and I have to plug a charger in. I'm sorry for your trouble.
Ms. Barenko, are you an attorney representing somebody in this hearing?
I am, Your Honor. Along with Scott Damich, I represent the Department of Technology Management and Budget, although Mr. Damich will be handling the hearing today.
Thank you. And Mr. Canzano, do you represent one of the parties?
Yes, I'm the representing the intervener defendant, Michigan Building and Construction Trades Council.
All right, thank you.
Okay, who is the intervener defendant again? I'm sorry.
Michigan Building and Construction Trades Council.
Okay, well, this is Associated Builders and Contractors of Michigan versus Department of Technology Management and Budget. And it looks like, yeah, we have an intervener who is, would you state it, please, counsel, because I don't have the name of the union in front of me.
It's the Michigan Building and Construction Trades Council is the intervener defendant.
Very good, thank you. And it is Court of Claims number 22-111 MZ. And this is a plaintiff's motion for preliminary injunction. And I missed is it Mr. Damage? Do you represent the plaintiff?
No, Your Honor. I represent the defendant, Department of
Okay.
Technology Management and Budget.
I'm sorry, I stepped out to get the charger and I missed it. Who represents the plaintiff?
That would have been me, Your Honor. Derek Wilcox here on behalf.
Thank you, Mr. Wilcox. You can proceed.
Okay. Well, we're here on two motions today, and they both obviously a lot of overlap. This is ABC's motion for preliminary injunction. And what has happened is the DTMB has made a new law or a rule regarding prevailing wage that bidders on contractors must pay the prevailing union wage in a district. And that leads to all sorts of other problems because that also means they have to structure their business around the employee category that is provided in collective bargaining agreements. It is our contention that this rule or law was not done properly and that it harms our client and all contractors who do not operate with collective bargaining agreements and is therefore impermissible. As I don't know how much you want me to bring in from the brief. I don't want to go through.
Well, as I understand it, I mean, you've got the four, factors for an injunction.
Mhm.
And then on the first one, you have the merits, which I think go to your arguments on separation of powers and rulemaking, and you
Right.
can discuss it as you wish.
Okay. Well, like I say, any legislation has to be specific. And when under the non-delegation doctrine, where an executive branch agency is exercising authority granted to it from the legislature, it has to be very specific. And in this case, there once was a
Mr. I apologize for interrupting. My screen froze, Your Honor. You said to Mr. Wilcox, he could discuss separation of powers and rulemaking.
Yes,
But then my screen froze.
I think that was it.
Okay, and then could you start over then for me, Mr. Wilcox?
okay.
I'm sorry.
Sure. Well, as I believe what you may have missed, where I said that the legislature needs to make legislation, obviously, and particularly under the non-delegation doctrine, where an executive branch agency is exercising some authority granted to it by the legislature, it has to be very specific in the legislation that they have this authority. Now, in the very recent past, 4 years ago or more, we had a prevailing wage statute that required prevailing wage to be paid on all contracts for public construction in the state of Michigan. This was repealed, and the basis of their claim seems to be, while it was repealed and that it was no longer required, it wasn't prohibited. And that's simply not the way the law works in this case, particularly for non-delegation doctrine, particularly not where the legislation was repealed by the electors.
But let me ask you a question.
Mhm.
What if the original statute had said that the state may not impose a prevailing wage requirement, and that was repealed? Would it then be your view that the state has to impose a prevailing wage requirement?
No, Your Honor.
Well, why the opposite then?
Well, because it's a very significant question. I mean, are you asking could the MTMB impose it, or could the legislature? Because
No, the DTMB.
No, they could still not. They could not negate it. Okay, could you ask the question again? Because
I'd be happy to,
Okay.
sure. So let's just reverse the situation. Let's imagine that we had a statute that said the state can't require bidders to follow prevailing wage.
Correct.
And then that was repealed.
Mhm.
Would it be your position then that the DTMB must impose prevailing wage because
No.
the thing barring it was
Right.
repealed?
No, because the DTMB still can only act within the strictures of their act, their statutes that tell them what they can do. And that's simply not one of the powers they have. What they can do are quite clearly enumerated. They have to, as I listed, they have to give a certain amount of leeway to veterans, and then they have all the discretionary power and so forth. But without a statute authorizing that power, they are not like a municipality where they can do anything that's not prohibited. They simply are limited to the things that they can do by statute. And the leeway they have are for very minimal items.
Doesn't 24207 provide exceptions from rulemaking pretty broadly when it comes to entering into contracts, even if it affects private rights?
No, Your Honor, because again, it's not that broad. It's simply not that broad as to make these giant class.
How much broader could it be? It says a decision by an agency to exercise or not a permission. I guess your permission is it's not permissive. Okay.
Yeah, it's not permissive. The permissive items are listed in there. They can work with other municipalities that can do other governmental things that can lease. Those are the permissive items they have.
Okay, so then in your view, if I have this straight, if the situation were reversed, I'm confused now because you're saying the DTMB would still have the discretion to not impose prevailing wage, even if the bar against it was repealed.
They would still not have the discretion to implement it because it's not in the MTMB statute. That's not one of the categories that they can consider when they are enacting a statute, when they're making a rule or a policy. Okay,
I follow you. Thank you. That's very helpful. So anything else you want to say about the substance before you turn to issues of harm, etc.?
No, I think the briefs cover it very well.
Okay, very good. It's an interesting question.
Yeah. The harm, sure. The harm, as I say, is that now ABC members will lose out. They do not have collective bargaining agreements. Therefore, they do not get to have any say as to the prevailing wage. They don't get any say as to the job classifications. They rely very much on the fact that they can provide the same service for a lower cost. A lot of them are small contractors, and that's their advantage. And now they're sort of locked out because they have to pay the rates that only the larger contractors.
Well, how do we know that locks them out? Why can't they bid higher and see if they prevail before we reach a decision that we need to impose something?
Sure. You're asking a business, why can't you provide a service that is that costs less than other people?
No, that's not what I'm asking.
But that is.
I'm asking what legal right do they have that's being infringed?
Well, there's the other statute about the fair competition in government bidding. I'm sorry, it's a mouthful and I don't remember the act right here without flipping through my pages, where it says they're not allowed to discriminate based on whether or not a company has a collective bargaining agreement in place.
Okay. I'm sure I've got it here somewhere, but do you happen to know the site of the statute off the top of your head? If not, it's okay, we'll find it.
Okay, it's in the brief. It's the
okay. I got it right.
It's generally related to the it's not prevailing wage. It's no, I'm sorry, I can't think of it. I'm sure John Canzano knows because
I've got it. It's 408.871 at SEC is the Fair and Open Competition in Government Construction Act.
Yes.
Yes.
So that is the harm. That this is one of the ways that they can compete.
Mr. Wilk, I apologize. My screen froze again. You said you could not think of the site, and then my screen froze again.
Right, and I spoke to Mr. John Canzano because he raised the issue related to this in his Sixth Circuit opinion. Can't remember the name of this. If you could cite the statute again.
Fair and Open Competition in Government Contracting Act. And it is in Government Construction Act.
Construction Act. It's a mouthful.
And 408.871 at SEC.
Thank you.
And I appreciate that, John.
Okay, so you were talking,
sure.
Mr. Wilcox, about harm.
Right. These are businesses where that is their advantage, that they are they can lower their costs. They can use job classifications that aren't the same as that existed, 70 years ago and whatnot. They can they just have flexible ways of getting the job done, and that's their advantage. And they lose that advantage now. Everyone's on equal footing on price, and that is the harm.
Okay.
Now, as one of the things that they noted, excuse me, just
I'll do the same. Mr. Wilcox, are you?
Yeah, I'm sorry.
Okay.
Yep. There's the question of irreparable harm. That's the second factor. And the irreparable harm is that if we lose out on bidding opportunities, as everyone has pointed out here, under the disappointed bidders doctrine, we don't get to challenge afterwards and say, hey, it was unfair that we lost these bids. Let's there's no compensation for that. Therefore, if we don't get the injunction, this is the only possible way to do it, is to bring it beforehand. The harm to the opposing party, if the injunction is not greater than the harm to ABC. I'm sorry, I probably mangled that, but there is no harm, Your Honor, in going back to the pre-March status quo here. There's no harm to the general public. If the injunction is granted, that's what happens. We go back to the same way it was from 2018 until March of this year. And that's simply no harm to the public in that time. Meanwhile, the harm to ABC, as I pointed out, is significantly greater in that their members will lose business and there's nothing they can do about it afterwards. And as to the harm to the public interest, well, they provided a bunch of studies. And of course, we could provide a whole bunch of studies on the other side saying that this is a good or a bad policy. But at this stage, as I say, again, going back, that all we would be doing is going back to the status quo pre-March 2022. So those factors are how we see it, and I think
well, we'd only be going back to, not legally, but the other argument, of course, is they'd only be going back to the status quo before then, I suppose.
Before 2018.
Yeah,
we've adjusted in that time, and I don't think, given the way that this was announced and put into place, I don't think everyone's even accommodated it yet, because they didn't put out the things until at least March and how to comply. And
have contracts been awarded since then that would be helpful for me to have a look at?
I would have to think so, but again, that's something we'd have to do in discovery, and obviously we haven't come to that stage yet.
Okay. Does that cover your argument on the injunction?
I think that covers all the main
You
points.
said there's a second motion. I'm afraid you talking about the SD motion?
Yes.
Oh, I'm not ruling on the SD motion today.
Oh,
I'm sorry. I had just planned on ruling on the preliminary injunction. We'll schedule well, either way, we'll have to schedule a summary disposition hearing, I suppose.
that's how it was noticed to us, Your Honor, and that's
well.
So I prepared, but that's fine.
I don't doubt that you received a hearing order with that, and I apologize, but we'll get the SD motion noticed up for hearing shortly.
Okay. Thank you.
All right. So who do I hear from? Is it Mr. Damage? Or
That's correct. Scott Damage here.
Damage.
And good afternoon. May it please the court. I'm Assistant Attorney General with the state of Michigan, and I represent the defendant in this matter, the Department of Technology Management and Budget. Your Honor, this court should deny the motion for preliminary injunction because plaintiff has not met the standard applicable to a proper preliminary injunction to issue. Specifically, if you look at the first prong regarding whether or not plaintiff is going a substantial likelihood of success on the merits, for the reasons stated in our briefing, along with in response to the preliminary injunction motion, as well as our motion to dismiss, plaintiff doesn't stand a strong likelihood of success on the merits. In fact, plaintiff's claims aren't even justiciable before this court.
Why not?
There have not, regarding standing and also rightness. Issue of standing, there, of course, with the Lansing Education Association, Lansing Schools Association case, there has to be a cause of action provided by law, which we don't have here. There has to be.
Isn't there a cause of action? I mean, they're seeking a declaratory judgment that that an action of the executive branch is in violation of either statute or constitutional principle. Why isn't that enough?
Well, Your Honor.
Apologize for interrupting again. Mr. Damage,
Yes.
my screen froze. You were talking about the issue of standing and rightness.
Yes.
And you said the issue of standing, and then my screen froze. So I didn't hear what you stated regarding the issue of standing.
Okay, I said the issue of standing, and if we look to the Lansing Schools Association case, one of the first ways that a plaintiff can be standing is to show that there's a cause of action provided for by law. And I believe that's when, Your Honor, you asked about the declaratory judgment piece of it. And Your Honor, back to your question regarding declaratory judgment, yes, that is a second way that standing can be met under this Supreme Court's decision in the Lansing matter. But that's only if there's actual showing of an actual controversy, which we don't believe that standard has been met here. The plaintiff here does not need a ruling from this court to guide its future conduct in order to protect its current rights. They have no current rights right now when it comes to contracts being let to them in this state. The law is clear as far as whether or not prevailing wages or the type of the wage policy at issue here. The petition language did not do away with the discretionary piece of the Department of Management and Budget Act, which allows for and in fact requires the state, the DTMB, to solicit competitive bids and whenever practical to efficiently and effectively meet the state's needs. And in doing that, the statute spells out that you have to find the responsive and responsible best value bidder. When we're looking at that and comparing it to what the petition language did here, there was nothing that restricted that discretionary language. All that happened was a repeal of an act. The language itself, the act is repealed, and then there was an appropriation of money to go ahead and make sure essentially that the word got out on the matter. There was nothing additional saying that as it relates to, for example, Section 261 of the Management and Budget Act, that the department doesn't have discretion, their department's discretion is limited in a way that it cannot require local prevailing wages in contracts for state work using state funds. And this is a great question to ask, because in response to the department's motion for summary disposition, I know you're not going to roll on that today, Your Honor, but there was a citation to the UAW matter. It is a UAW versus Central Michigan University, and regarding plaintiff's claim that under that case they did meet the declaratory judgment piece of standing. That case is not, there's a significant difference between that case and here. There is an actual particularized injury that the plaintiffs in that matter, their members, were going to face. You were dealing with employees and their right to run for political office. And there was a statute that was called into play and a policy that arguably did not jive with that statute itself. Here we don't have a statute that's conflicting at all with DTMB's discretion. And when we look at the statute itself regarding the DTMB's discretion, there are limits. There are limits on DTMB's discretion in entering into contracts. It's just those limits do not include not requiring a specific wage or not. The legislator knows how to include that type of language. We cited the Local Government Labor Regulatory Act, and where there's a specific section that shows where the legislator said that you can't require prevailing wages. The legislator could have done that here. It didn't happen in the petition language that the people put forth. And the legislator has since not said that, in fact, you can't include prevailing wages. So it's kind of a long-winded answer to your declaratory judgment piece, Your Honor. I just don't think that the standards have been met for there being an actual controversy that's necessitating the sharpening of the issues brought before you, Your Honor. Certainly not by this plaintiff.
Well, given that the rule against the losing bidder for standing or for ability to bring a claim, how else are they supposed to challenge this action?
Well, there's certain ways that look, the ability to challenge the state's contracting ability, it is very limited. But there are ways. I mean, if there's fraud involved, if there's if there's illegality or abuse, I believe that the precedent discusses those areas.
Yes.
But that's not what's been. That's not what happened. That's not what was happening here. There's not been sufficient facts pled for fraud. There has not been abuse. In fact, if you look through the announcement from the governor through directives all the way up to the administrative guide that was issued by our client, everything was followed through here, but it was above board. This is an executive decision within her purview, within her power. If another executive and wants to come through and say we are not going to require prevailing wages, there's nothing preventing him or her or them from doing so. And back to your original question to opposing counsel regarding what if the Prevailing Wage Act before had said that the state cannot require prevailing wages, and then the petition language came through, what would that do? That scenario is exactly what the plaintiff would need here to get rid of the prevailing.
Well, I think Mr. Wilcox's response to that was there simply isn't a legislative grant to even give them permissive authority. So what's your response to that?
I have a few responses to that, and they're all born out of the statute itself. If you look at the Management and Budget Act, section 261, specifically subsection 2 of that section, the statute states that departments shall make all discretionary decisions concerning the solicitation, award, amendment, cancellation, and appeal of state contracts. Mm-hmm. And also from there, if you jump to section 241 of the Management and Budget Act as well, the state is required, the DTMB is required to award construction contracts to what is called the responsive and responsible best value bidder, which that phrase, responsive and responsible best value bidder, is specifically defined in that very statute itself to include certain items. The best value bidder, part of that definition, is not the lowest wages paid to your employees. And in fact, going back to the preliminary injunction piece here, Your Honor, if you look at the independent studies that were put forth by us in peer-reviewed studies, requiring prevailing wages actually will further the responsibility of DTMB to efficiently to have a competitive solicitation to efficiently and effectively meet the state's needs. Higher wages, you're going to get better outcomes from your workers themselves. There's a few different areas there that speak to the idea of having a higher wage in your end product of what you're paying for. And so back to the statute, that's within the purview of the executive. And there are areas that are restricted, as opposing counsel pointed out. There's veteran preferences that have to be included. Mm-hmm. Right. There's also a portion, section 241, subsection C, that talks about qualitative components as well. And that's a permissive portion of the statute. And it also lists a few areas out that with the misnomer, including but not limited to. One of the third elements of, I want to say it's an element, one of the third characteristics are the quality of proposed personnel. The idea that you're going to have higher paid wages here that are commiserate with the locality, you're going to have happier workers. You're going to have a better work product. You're more skilled workers. It's going to lead to a better product, which again that's part of the DTMB's responsibility to efficiently and effectively meet the state's needs. And also requiring prevailing wages, it puts everyone on an equal playing field. And when it comes to competitive bidding, having that area on a level playing field makes sure that everyone's being treated fairly. So again, there's a bunch of different.
Well, that I don't quite get, but I mean, people present all advantages and disadvantages in bidding. I'm not sure why the wages somehow stands out to have a level playing field in and of itself.
Well, in your honor, I appreciate that because you're right. Looking at wage in isolation, that doesn't make an individual the best value bidder. There's going to be other things that are going to come into play whenever it comes to contract bidding and letting of those bids, other than wages. Is our exhibits in response to the motion of preliminary injunction pointed out, wages are roughly maybe 20 to 25% of the overall cost of a construction project itself. That leaving 75% of the other areas to go ahead and make up for. Or be part of the process of deciding whether or not to let a contract. But I tend to disagree, though, Your Honor. The idea of requiring prevailing wages puts everyone on a level playing field. It does. It prevents lower wages and lowballing bids in a way that would prevent other entities from getting that bid in a sense. So. But back to the to the success on the merits, we just don't think that there's a substantial likelihood there's certainly not a substantial likelihood of success on the merits in this case, Your Honor, for a motion for preliminary injunction to issue.
Is that the requirement, substantial likelihood?
I believe so. It is. Okay. It is. Yeah, substantial likelihood of success on the merits, and then the other portions of as far as irreparable harm to plaintiff. Plaintiff looking at plaintiff in isolation as a group representing members. The plaintiff doesn't have any specific injury. In its members, there has not been a single bidder or a single one of its members put forth on the record here who, like you said, has been harmed by this policy. It's purely hypothetical. And asking this court to issue a preliminary injunction to stop the state's policy on that matter based off of a hypothetical scenario certainly is not the standard that our state's jurisprudence has in mind when it comes to granting preliminary injunctions. And in fact, and then looking at the harm to plaintiff and its members if in fact the injunction does not issue. I go back to one of the first statements we made in our response to the motion to preliminary injunction, Your Honor. The motion came months after this pronouncement was made. To the extent that there was immediate harm to its members, this probably should have been filed earlier. Now, timing aside, and as you pointed out with disappointed bidders, there's really no harm other than being denied your bid not being let, and certainly that harm is no different than any other to plaintiffs' members as opposed to anyone else in this state. Now,
Mr. Damage, I'm sorry to interrupt again. My screen froze again. You were talking about the motion for preliminary injunction. The motion came months after the pronouncement was made. And to the extent there was immediate harm.
Yeah, it's the extent there was immediate harm that I'll pick up from there. To the extent there's immediate harm, perhaps plaintiff's motion should have came sooner rather than later like it did here. And also when we look at the we'll go to the harm to plaintiff's members itself in denying the preliminary injunction motion. Again, without the absence of any evidence showing any of its members that have been specifically harmed by this policy, again, I don't think that adjunctive relief would be the proper use of adjunctive relief in this matter. Now, switching over to the harm to DTMB and the rest of the population of the state. We'll start with DTMB. DTMB has, of course, issued a policy here that requires prevailing wages in other areas. If in fact that is stricken, it removes the status quo right now. We go back to prevailing wage policy times, and there are projects. There are projects going on right now. Would they be covered by the prevailing wage policy? Sure, they probably have to be renegotiated as well.
Wait, are you saying that there are contracts that were entered into under the previous governor that now have to be renegotiated because of the policy?
No, what I'm saying, potentially that could be a potential scenario if in fact the prevailing wages are deemed, if that policy is deemed to be improper, because contracts have to be renegotiated. Wages would have to be renegotiated as well, at least lower, and so And then we talk about the workers themselves. When we talk about prevailing wages, we're not just talking about how much you're making an hour in a dollars and cents standpoint. There's also fringe benefits built into that as well. Prevailing wage is not only just your dollar salary. You could also meet the prevailing wage, or contractors can meet the prevailing wage by including fringe benefits. These are human beings. It will come to find that their wages have been slashed or lessened, and including their fringe benefits. So the harm to those individuals in DTMB are much higher than any harm or any hypothetical harm that will come to plaintiff or any of its members. For all those reasons, Your Honor, we don't believe that this court should use its extraordinary powers to grant the extraordinary writ of an injunction to stop the state's policy.
Well, I'm sorry, go ahead.
No, okay, I was going to switch over to motion for summary, which I know that you said we're not talking about today.
Well, actually, here's now that I understand that, we're getting into the substance more. I just didn't realize that it had been noticed. It's a possibility that I would consider after this ruling on the SD motion without another argument. So my question is, how do the two lead counsels here feel about that? And is there something else you'd want to say today that would make that acceptable to you? I don't want to deny anybody argument. I like people to come in for argument, but if we're just going to say the same things, maybe that isn't very efficient.
I don't think oral argument is necessary on the summary disposition after today, but I leave it to fellow counsel.
Thank you, Mr. Wilcox.
As much as I like to come and argue, Your Honor, I tend to agree with Mr. Wilcox on that matter. It would be so much of the same. Of course, part of the analysis for a preliminary injunction requires you to address the merits, and I think we both have done that verbally and in writing.
Yes.
In addition to intervening defendant as well, what they had to say on the matter too.
And there, Mr. Is it Canzano?
Yes.
And then is it Ms. Barranco?
Correct, although I also represent the Department of Technology Management and Budget.
I see. Okay, so you're not arguing today.
Correct.
All right. Mr. Canzano, did you want to add anything?
I do. I would like to just make a few points. And I'll leave my points to the merits, which go both to the likelihood of success on the merits in the injunction motion, as well as to the summary disposition motion. The legislative grant of authority to the Department of Technology Management and Budget to make all discretionary contract decisions includes a whole host of permissible contracting criteria that the legislature did not need to specifically prescribe. For example, the quality of materials on projects. The department can say, we want AAA grade bricks, not just grade A or grade B bricks. And the legislature doesn't have to go into that kind of micromanagement.
Right, and it would be odd, I suppose, to have someone come in and say, we want to use these other bricks and we have a right to use them.
Right, and say that our normal business practice is to use the grade B bricks. They're just as good and they're cheaper. And the state has the right to say, we want the best. And that is essentially what they're doing with the prevailing wage law, is trying to raise the standard of quality of the workers. All kinds of things like that: scheduling, construction processes, qualifications of personnel. Those are all kind of contracting requirements that the state has the discretion to prescribe, and the legislature did not specifically grant them those powers. That's part of their discretionary authority.
Mr. Canzano?
Yes.
Please forgive me, my screen froze. You said the prevailing wage law is trying to raise the standard of the quality of workers, all kinds of things like that: scheduling, construction processes, qualifications, and then my screen froze.
I think you got it all, but I'll leave that to Mr. Canzano.
I think that was all on that point.
Okay, good.
The Local Government Labor Regulatory Limitations Act, MCL 123.1381, specifically prohibits certain governmental units from requiring prevailing wages. And conspicuously absent among those governmental bodies is the state, and in particular, the definition of, there's a definition of covered educational institutions in that law. And it's conspicuously absent are the state universities. So it covers community colleges, school districts, other educational, but does not include the state universities. So again, the legislature could have specifically prohibited the state, but did not. Likewise, the Fair and Open Competition in Government Construction Act does apply to state government. And that prohibits requirements for certain terms in state contracts, including the requirement that the bidders agree to enter into a project labor agreement, or that the bidder must be a party to a collective bargaining agreement. That's prohibited in that law, but that law does not prohibit prevailing wages. So again, the legislature knows how to prohibit. And then the last thing I wanted to say is there's a discussion of your decision in the Mothering Justice case regarding the initiative process and the legislature's ability or how they can amend an initiated law. And in this case, they could have proposed an alternate law on the same subject, which was not only are we going to repeal the Prevailing Wage Act, but we're going to prohibit prevailing wages on state projects, prohibit the state from enacting prevailing wages, just like we prohibited the state from requiring project labor agreements in the Fair and Open Competition Act. So I think that's all I need to say.
All right, Mr. Wilcox, back to you. Would you like some rebuttal?
Sure. First, as to start with his last point, as we've all agreed, the legislature didn't write this law. So when we're interpreting what it means, we ask, what did the people mean? What did the people mean when the electors submitted a proposal to repeal prevailing wage? And I submit to you that it's quite simple. They meant that the state shall not have prevailing wage laws. If we as lawyers and perhaps legislatures would know, well, yeah, but then there's other ways around it, subterfuge and whatnot. But when the people enact a law, it means what the people say. And the people said, we repeal the prevailing wage requirement in Michigan. I think it's quite clear that they meant we shall not have this prevailing wage law, not that we get to enact it through another backdoor method. I want to correct Mr. Damich, although I don't know, perhaps he's reading from a different case than I am, but the test for issue of injunction is not substantial likelihood, it's just likelihood, at least according to Hamill versus Speaker of House of Representatives, 297 Mishap 641, 2012. Maybe there are other cases that add substantial. I haven't seen those. Regarding the timing on the matter, Your Honor, we submitted FOIA requests as soon as this policy was announced, asking where is this coming from, how is this being enacted, what authority is this, and so forth. We didn't receive responses to those FOIA requests until I believe we received one in May. ABC had another one that wasn't responded to until August. So I have to admit, we were initially flying blind when we challenged this because we still didn't have a basis for where they thought they had the authority to do this. And of course, in their response, they finally provided the MTMBA statute that they're relying on. But as far as us sitting on our hands, you know, we challenged pretty much as soon as we could after we knew what they were claiming, the basis of their claim. We brought this in July, it was enacted in March, and we got our FOIA responses, or still haven't got FOIA responses in between that time. So I think—
when you say it was enacted in March, I'm a little confused.
It took effect in March. The governor announced it in—
the new policy.
Yes, the new policy, yes. Okay.
Gotcha.
Announced it in October, and we immediately asked, okay, where's the directive, what's going on? And got nothing.
Right. I'm with you there. I know what you're talking about.
Right. The very first FOIA request we put in October, we got a response that there are no responsive documents in response to how the governor had communicated to the MTMB, and I forget the exact FOIA request. I believe it's in the complaint. But I just want to show the court that we have not been sitting on our hands. We've been trying to figure out what's going on and challenged it as soon as we thought we had enough to bring the suit and bring the injunction. Again, we've only asked for prospective relief. If you were to issue an injunction, I don't know how that would affect any existing contracts unless the contract contained a clause that we are going to renegotiate in the future for some particular reason. So I just don't think that's appropriate. And in response to them saying, well, good paying jobs, there's a big issue and people will be hurt if they don't have good paying jobs. I think that these are still good paying jobs, even without the prevailing wage law, and ABC contractor employees are people who need jobs just as well. And so, if the injunction if the injunction does not issue, they'll be hurt. So pleased to, people needing jobs, obviously it works either way. And in our case, it certainly works for our contractors who need positions. We have not had, he compared the prevailing wage law to using a different grade of bricks. We have not had, Your Honor, back and forth laws regulating the use of bricks that I'm aware of, but we have had laws implementing prevailing wage and then repealing prevailing wage. So it's not a simple matter as the quality of bricks. It is a matter of substantial public importance that they've passed legislation on in the past, and I don't think that they can get around that fact with a simple stroke of the pen comparing this to what color form they're using at the time. This is a major decision and it should be handled by the legislature.
Well, so is it your position? I mean, I don't even know what statute is referring to that a governor, no, whatever, the DTMB could not impose a brick requirement?
No, they could, but they could. And I believe without going, since obviously when I was doing this, I read the act, but I don't know how many pages, and I only paid attention to the things that had more specific application. But I'm sure in somewhere they can control the quality of goods. And I have no doubt about that. And so I don't think they need a statute to tell them specifically about qualities of bricks.
Okay.
They mentioned, of course, that they think that they have better outcomes with a prevailing wage law in action, but I noticed that we had one until 2018 and went without one. And so we had 4 years, almost 4 years without one. They haven't mentioned that the quality of workmanship went down or anything similar to that. If this had been done the proper way, where legislature had debated it, or if they had gone through the Administrative Proceedings Act, people would have a say on that and we might have some information. But they bypassed both of those steps and just said we can do it with a flick of our pen, and so we don't have anything to go on.
So if there was no prevailing wage law initially, okay, and a governor comes into office or DTMB is established that says, okay, this is part of our discretionary requirement now, you have to pay X number of dollars, fringe benefits, etc. Your position is that determination would be ultra vires.
Yes, for wages, yes, that would be ultra vires because they simply don't have that in the statute. They don't have any grant to make that call in the statute. But if they did have such a grant, then they would have had to gone through the APA. Even if the statute says they have some discretion, they have to still go through the APA. And we dealt with that pretty extensively in the summary disposition motion, Your Honor.
Okay.
I guess those are the points I wanted to make, Your Honor.
Sure. I appreciate the arguments. I appreciate the briefing, all of which was very interesting and helpful. I will prepare a decision and issue it hopefully within 30 days. I can't guarantee it, but that's where we make an effort and we typically get there. Is there anything else anybody wants to tell me about either regarding the issues or regarding any practical matters concerning the case before we conclude? I'll take that as a no. I'm sorry, Mr. Wilcox.
Sure. I don't know if in the interim you wanted to issue a scheduling order, if we should proceed with discovery.
Yeah, I mean, if I don't, if I get an order, well, we're going to have discovery either way. Typically what I do in cases is I send out a letter to the parties and say, tell me what dates you can agree on. And if you can't agree on dates, then I'll do it. Okay by you if I send one of those out as opposed to just issuing an order?
That works for me, Your Honor.
Your Honor, respectfully, we asked for, we don't think there should be discovery in the matter. We moved to dismiss and move our answer. So we wouldn't, we probably would object to the entry of a scheduling order, especially for discovery reasons.
Well, I don't typically hold off discovery because someone filed an SD motion, but I'll certainly have a look at it depending on how I'm going to rule on the motions. But I generally favor proceeding with discovery promptly rather than having it sit around and potentially go upstairs before we even begin to learn anything about what's underlying the case. So I will consider the issue of a scheduling order and either issue one, send a letter, or indicate that I'm not going to issue one until after the SD is determined. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
Okay, very good. Thank you all. And the matter is concluded for today.
Thank you, Judge.
Thank you.